Marriage, property and equity, the evolution of Kenyan law. May it please you. For years in Kenya, when marriages broke down, one question ruled the courtroom: who paid? If you did not prove your financial contribution, you walked away with nothing. That was the era of Peter Mburu Echaria v. Priscilla Njeri Echaria 2007 Ackler. The rule was strict: tangible financial contribution was king. Homemakers, those who raised children, managed homes, supported careers, often stood before the court empty-handed. But then came the Constitution. Article 45(3) declared that parties to a marriage are entitled to equal rights at the time of marriage, during marriage, and at dissolution. Many believed this meant one thing: automatic 50-50, but the Supreme Court had to answer the real question: what does equality mean? In Joseph Ombogi Ogentoto v. Martha Bosibori Ogentoto and two others 2023 KSC for KLR, the Supreme Court gave clarity that reshaped Kenyan matrimonial law. Equality, the court said, is equality of status, not automatic equal division. Marriage is not the splitting of an orange in two. You do not walk into court and demand half simply because you were married. Instead, the court asked a deeper question: not, to whom shall this property be given? But, whose is this? That shift changed everything. Because the Supreme Court did not return us to the harshness of Echaria. No, it expanded the meaning of contribution. Under the Matrimonial Property Act, contribution includes not only money, but domestic work, childcare, companionship, management of family business, farm work. The invisible labor of marriage became legally visible. Now, if one spouse contributed 30%, whether through income or through raising children while the other built wealth, they are entitled to 30%, not charity, not sympathy, but lawful recognition. Marriage became what it truly is: a partnership of equals, where property follows contribution, broadly defined. But then arose a harder question: what of those who never married? Thousands of Kenyans cohabit. They build homes together. They raise children. They acquire land, but they never formalize their union. What protection does the law offer them? This is where the Supreme Court delivered a second revolution. In Mary Nyambura Kangara v. Palagari Mayaka 2023 KSC 15 KLR, the court confronted the legal vacuum surrounding cohabitees. For decades, courts relied on the presumption of marriage doctrine from Hadan Wanjikiyo v. Public Trustee. If a couple lived together long enough and held themselves out as married, the law presumed a marriage. But in Kangara, the Supreme Court tightened that doctrine. It declared the presumption of marriage is now the exception, not the rule. It laid down strict parameters. Long cohabitation alone is not enough. There must be legal capacity to marry. There must be intention to marry. There must be consent. The parties must hold themselves out as husband and wife. The burden lies on the one alleging the marriage. And any rebuttal must be strong, distinct, and conclusive. In Kangara itself, the claim failed, because one party was already married to someone else. There was no legal capacity, no marriage. The presumption doctrine, the court said, is on its deathbed, but here is the brilliance. The court did not leave the cohabiting partner with nothing. Instead, it invoked equity, constructive trust. The court held that where two people cohabit, contribute to property, and share a common intention that both will benefit, a beneficial interest can arise, not as spouses, but as contributors. In Kangara, the court awarded 30% to the cohabiting partner, not as matrimonial property, but as property held under a constructive trust. That is the breakthrough. Even without marriage, equity follows contribution. Today, the legal position in Kenya is clear: for married persons, equality of status. Division based on contribution, monetary and non-monetary. No automatic 50-50 for cohabitees. To roots, prove a presumption of marriage under strict parameters, or prove contribution and common intention, and claim a share under constructive trust. The law no longer forces marriage where none existed, but it does not ignore contribution either. Marriage is a partnership of equals. Property follows contribution. And where there is no marriage, equity follows contribution just the same. That is the evolution. That is the revolution. And that is the law.